My name is Jeff Farnsworth. Distinguished guests, ladies and gentlemen, it's my honour and privilege as the President of the Chartered Institute of Arbitrators in Australia to welcome you all to this webinar tonight on artificial intelligence in the courts and arbitration, servant or ominously servant or Skynet. The Chartered Institute of Arbitrators is really pleased to be able to run these seminars in collaboration with the Australian Federal Court. The Chartered Institute is a global network of arbitration, leading global network of arbitration practitioners who are rising, I'd like to think, to the challenges posed and the opportunities posed by artificial intelligence, which will be unpacked and discussed, I think, in this evening's seminar. I'm particularly grateful to the efforts of the counsellors, the Ciarb Australia branch counsellors who are sitting on the panel today, and in particular, I'd like to mention Christian Maley, who has done a power of work in bringing this together. So without any more words from my end, I'd like to, I think, pass over to His Honour Justice Futrell to introduce the speakers.
Thank you, Jeff. All right, so we have 4 panellists for this evening's seminar, and I'm personally quite interested, I should say excited, but I'm quite interested to hear what everyone has to say about this topic because, as you may or may not be aware, I'm on the Court's Artificial Intelligence Committee, which is in the process of considering how this court will respond to the challenges associated with generative AI. So the 4 panellists are Kristen Bauer, Ellie Bernstein, Tom French and Christian Maley. And I'll just briefly give you, for those who don't or are not familiar with them, Kristen Bauer is the Director of the External Affairs at the Chartered Institute of Arbitrators. She leads the policy team at Ciarb in London that develops the Institute's practical guidelines, including a recent guideline on the use of artificial intelligence in arbitration. Ellie Bernstein is a partner of Moto Legal, which is a technology practice with offices in Sydney and Dubai. He is chair of the Law Society of West Australia's Tech and Law Committee. He's been involved in with the development of policy guidelines and governance frameworks for the use of artificial intelligence. Tom French is a partner of Minter Ellison based in Perth. He practices in dispute resolution, including arbitration, with a focus on projects, construction, energy and resources. And Christian Maley is counsel with Clifford Chance, based in, I think he spreads his time between Perth and Singapore. His practice focuses on international arbitration of construction and project disputes and investor-state arbitrations. He's a counsellor and vice president of Ciarb Australia and chair of the Ciarb Australia Young Members Group. All members of the panel are well placed to speak on this evening's topics. I will moderate. We had hoped to provide participants with the ability to ask questions during the session, but unfortunately that technologically has not been possible. But I hope that the questions that I will ask, which are intended to encourage discussion between the panellists, will answer the majority of any questions that participants may have on this topic. It's quite a dense topic. It's quite obviously topical, and we'll see how we go to get through what is quite an extensive list of topics. So if we start then by reintroducing Kristen Bauer, who will provide you with an overview of the recent Ciarb Protocol.
Thank you so much. Hello, everyone. It's a pleasure to be with you all and to be invited to be part of this conversation. Huge thanks to the organizers for pulling together this multi-stakeholder group to discuss the use of AI. I think that's a really important element of this discussion, and I really appreciate being invited to be part of the conversation. So I'm going to give a brief overview of Ciarb's guideline on the use of AI in arbitration, but I want to just zoom out a little bit and give a little bit of context. So as Jeff said, Ciarb is a global professional membership organization. We have around 18,000 members in over 100 jurisdictions. We develop professional practice guidelines for arbitration, mediation, and adjudication. And these guidelines are soft law instruments which are designed to support neutrals, experts, counsel, parties in the dispute resolution process. And they cover a whole range of topics. They're available for free on our website, from things like applications for interim measures to security for costs, expert witnesses, etc. And in March of this year, we published a new guideline on the use of AI in arbitration. So our technology thought leadership group launched the AI guideline drafting committee back in 2022. And part of the impetus to develop this guideline was because we were seeing sort of a few things come together. One was this real evolution in Gen AI tools in the market. We saw many more kind of off-the-shelf solutions that were making Gen AI more accessible, more affordable. And of course, we saw a real boom in kind of adoption and uptake in the kind of 2020, 2021, 22 period in the use of AI, which was really driven by the launch of free tools like ChatGPT and Claude. And so all of this together presented, really exciting kind of use cases for the industry, but also equally unleashed a whole set of new risks and complex challenges. So kind of against that backdrop, we decided to develop these guidelines on the use of AI in arbitration. And what we hope is that they provide a clear, structured framework for the responsible and transparent use of AI in arbitral proceedings that allows folks to take advantage of the benefits of AI while also supporting practical efforts to mitigate some of the risks. Because ultimately what we want to do is, AI is here to stay, but we want to ensure that we're preserving the integrity of the arbitral process, preserving, parties' procedural rights, and ultimately ensuring or kind of preserving, I guess, the enforceability of any award coming out of the proceedings. So the guidelines, while they're designed for use by anyone in the arbitral process, so experts, counsel, parties, we were really focused on the arbitrators themselves as our kind of target audience and users for these guidelines. So I'll just briefly give you an overview of the structure of the guidelines. So it's divided into 4 parts. Part 1 outlines the benefits and risks of the use of AI in arbitration. Part 2 sets out some general recommendations on the use of AI. So it's really and I would say the general recommendations kind of emphasize something that's a through line in the guideline, which is that AI tools should be verified and approved by human users. And importantly, that arbitrators should not delegate their decision-making responsibilities or accountability to an AI tool. Part 3 addresses arbitrators' powers to give directions and make rulings on the use of AI by parties in arbitration. So it outlines kind of when and how tribunals may regulate the use of AI by parties or counsel. There's a framework for ruling on the admissibility of AI and AI-generated material in the record. There's a framework for disclosure, which we'll get into shortly. Part 4 addresses the use of AI by arbitrators. And here, again, it touches on kind of discretion of the tribunal and transparency. And then finally, there are 2 appendices. Appendix A is a template agreement on the use of AI in arbitration, and Appendix B is a template procedural order. So the last thing I'll just note here about the guideline is that typically our guidelines, we try to draft in a way that kind of future-proofs the guidelines to not be updated so frequently, but kind of given the nature of AI and the kind of rapid development of use cases, the evolution of the tools, and the really evolving legal and regulatory landscape happening globally, we made a decision that we would be turning to review and update the guideline kind of on an annual basis to make sure that it's still current and in line with not only the legal developments happening globally, but also what's happening in practice. So with that, I'll pause there and turn the floor back over to Justice Futrell.
Thank you, Kristen. All right, so now we'll get into the meat of this evening's seminar. If we could start off by asking Christian, obviously before I start, I should say we're going to assume a degree of knowledge and that people understand what generative AI is, that it's distinguished from narrower AI. So we're really focusing the attention on generative AI. And my question for you, Christian, is how is Gen AI currently being used by parties and counsel?
Thanks. It's certainly an interesting question. I think I just frame my comments with reference to the Pareto principle. And by that I mean, I've found that generative AI in my practice delivers the most value and is usually most appropriate for those tasks where you need to get 80% of the way there, perhaps with 20% of the effort, but don't need that 100% certainty with the extra 80% of effort. So with that in mind, a couple of key examples that I'd highlight, and I'd be interested in any comments from my co-panelists. But the first one is when you're really at the early stages of a case and need to get across the dense bundle of materials, and our beloved clients, of course, often shower us in documents at the start of the case and ask us to figure out what's what. I found that this is really a very strong use case for AI. We have at my firm a platform that we use called Wexler AI, which I've used on a recent case to essentially throw all the key documents into it and have it try and identify as best it can the chronology of key events, key issues, and so on. Varying levels of success depending on the type of case and complexity, but I found it to be of worthwhile utility in all cases. The second practical example I'd give, and this is again based on some quite recent experience, is just in the practical day-to-day tasks of taking witness statements and witness interviews. We make good use of the automated transcript features on Microsoft Teams in our environment, and I've found that can often, sometimes half the number of fee earners that need to be in a meeting to get best use out of it, rather than having a trainee or an associate colleague there taking notes. That can be handled by the AI transcript, and of course it's also very effective to pull out the action items afterwards. So there are just a couple of examples of how I found we've been getting good use of generative AI in our practice.
In addition to Christian's comments, and thanks, Christian, we've been using it in a quite a tangible way in respect of discovery, and it's quite interesting in the context of discovery because technology has played a part in driving efficiency in discovery for many years now, and long before AI has become a significant issue within legal practice. And AI is now improving those efficiencies over the typical, what they used to call TAR, or technology assisted review. And I've found recently in some big discoveries where we've been estimating the costs based on the different options using different technologies, that the savings of incorporating AI into the TAR process are very significant, and the risk, from what I understand from our technology experts, are relatively low.
And when you say risk, what risks are you alluding to?
Well, the risks are the typical risks in outsourcing discovery from humans, and I guess it's just a different risk to human error. but missing relevant documents, let's say, in primary review, or miscoding relevant or irrelevant documents. Now, we have a number of structures in place, obviously, to manage that risk, including secondary review and checks of those, but there's always a degree of risk when you're delegating a task to a non-human.
Document production is in some ways an exercise in risk mitigation all the way through the process. The risk can't ever be entirely removed when you're reviewing 150,000 documents, I suppose.
That's right. And we find in applications before court, for example, in respect to discovery, depending, of course, on which judge we're appearing before, it's very much encouraged that we'll be using technology to some degree, given the significant cost of discovery to the parties and the delay to proceedings potentially.
All right, perhaps we'll move to a related but slightly different topic and direct my question here to Ellie, which is what generative AI tools or applications are emerging or on the horizon, I suspect, for legal practice.
Yeah, if I can just carry on from the points that were just previously made and try and link them in. So I think that the functions we've so far discussed are discovery or basically the initial stage of onboarding information, right? Selecting that information and that discovery process. Then the next stage would be something like research. I mean, AI has been used in legal research for a while. And then taking that step further, generative AI in terms of generating submission, evidence, the generation of material, whether it's factual material, such as witness statements, or perhaps legal submissions, which rely more on so the first would rely more on the discovery process, the second would rely more on the research process as its input, right? So those are typically what we currently have to date. The missing piece of the puzzle, or the part that we don't, and Ciarb correctly sort of excluded that, is the actual assistance in the decision-making process itself. That is to say, for the arbitrator or for the judge to actually look at statistical analysis, understanding based on this information, what's the range of outcomes that other judges have given or other arbitrators have issued or predictive settlement sort of modeling for this particular case. Now, the issue there is obviously cannot replace the function of the arbitrator at the moment, and that would be a natural justice issue if the cognition or the decision making of the arbitrator was replaced with AI. But even if that wasn't the case and it was sort of suggestion only, there would be a bias. There would certainly be a potential case that biases the judge or the arbitrator's views in narrowing the framework of what they would otherwise have decided. So there's some issues around that side of things. Where potentially that decision-making aspect of AI could come in is in smaller claims, and I think Justice Butcher mentioned that in our discussions previously. In small claims from tribunals where it sort of makes sense for AI to take a more active role, even in the decision-making process itself, either to assist a magistrate to make a decision within 5 minutes, or alternatively, and I'll discuss that a bit later on, taking the role of a AI arbitrator effectively. So I'm not quite sure if I've answered the question, but in short, the role is moving down that chain from just preparing information to actually making decisions on that information.
And maybe if I could just jump in to add one or two more examples, which is that, it's already been mentioned, kind of witness prep and things, but we are seeing that within big law firms. I'm hearing a lot from members and colleagues about the use of AI agents and things to help witness prep and questioning, cross-examination, all of that. We also have seen the rise of more of these AI agents as tribunal secretaries. Again, that's a little bit dicey in terms of over allocating decision making, but we We did a demonstration in Hong Kong in March with our East Asia branch and Brazil branch on the testing out a tribunal secretary, one of these AI agents. And actually the submissions were so good that for the purposes of the demonstration, we kind of tweaked it and pared it back so that it wasn't actually so good, because it was kind of terrifyingly really good at its job. So those are some of the things that I think in the sort of agent space that's more at the cutting edge of, I guess, where we could see things going.
Well, I think we'll have to just whet people's appetite with those enticing ideas, because I suspect that topic could well become its own entire seminar, if not now, certainly at some point in the future, because the future is coming to us, whether we like it or not, I think, on many of these things. But to deal with some of the more immediate, what's emerging sort of as we speak, I'm going to ask Christian, what are some of the important risks that can arise from the current use of generative AI, what's on the immediate horizon by parties and counsel in arbitral context?
I suppose, thanks for the question. I suppose the big one that's probably most on everyone's minds is hallucination and the risk of error in getting the answer wrong. And I feel like it's now at least once a week that I'm seeing news articles about an unfortunate lawyer somewhere who has used generative AI to find case citations without checking them. In preparing for today, I did come across a database by one Damien Charlton of hallucinations appearing in references to hallucinations in court judgments. And Mr. Charlton has amassed 225 cases to date. So there's a growing corpus. This is globally. I'm not going to take you through all of them, but there's a couple of examples that I think were interesting and worth noting. One is a decision of this court from earlier this month in the case Murray and the state of Victoria. That case is notable because it was a case where there were hallucinated citations, but they weren't case citations like we see in many of the other decisions. These were references to was anthropological reports, actually, in the context of a native title claim. The background to this was that the junior lawyer who had prepared this had used Google Scholar to find these citations, which I personally used while I was at university just as any other search engine for academic articles. But the judge found that because of the AI features that have been integrated into Google Scholar now, this is what led to these hallucinated references. So I think it just goes to show that now it's not only in the obvious places that we might be finding AI, and there may be caution even in everyday tools such as search engines and things like Google Scholar. The second one I think is worth noting because of some of the colourful language used by the judge, and this is from the US District Court of the California District. The case is Lacey and State Farm General Insurance. Not the highest by number, but perhaps pretty high up there by proportion of references. 9 out of 27 cases cited in the brief were hallucinated. Also notable because this brief went through 2 separate law firms acting for the plaintiff and they weren't picked up. And the judge rebuked that lawyering with as much expertise in the craft, his rebuke was that the parties were lawyering with as much expertise in the craft as an actor playing a lawyer on a TV show. So somewhat critical. There are obviously many other risks that my co-panelists might want to highlight.
Yeah, in terms of most people are probably familiar with hallucinations, etc., and where practitioners have been caught out. One of my concerns, perhaps a softer concern, but it's in relation to the next generation of lawyers coming through who are going to grow up with this technology and so may develop a different sort of discipline in practice. Because the way that I don't, you can probably tell from all the paper around me, I'm not that tech savvy and I don't use AI that much yet. But if I was to instinctually, I would probably follow my usual process of going to primary sources and researching more and coming up with an answer, and then perhaps sanity check that answer to see if there's anything I'd missed, etc., etc. But if we get a generation of lawyers coming through using it in the first instance, it's going to change the usual process of legal research and analysis. And perhaps that's inevitable, but I have some concerns as to in relation to an over-reliance of it in the usual process, and whether that will sort of change the ability or approach of the next generation of lawyers.
And if you take that,
Eli.
sorry, if you take that further and you take that step further, the next generation of lawyers to self-represented litigants who would be now using Gen AI without really knowing potentially the right question to ask or seeing whether an important point has been missed. And like Christian said, it is an 80-20 Pareto sort of equation at the moment. And there is that 20% of navigation that the lawyer has to still input. But once you have that out of the mix, the quality of the submissions might go down. That said, with time, that 80-20 won't be 80-20. It'll be 99-1 or 95-5 or whatever whatever that equation is as that improves. So we need to ensure that it's not garbage in, garbage out. The other element in terms of issues, I think there's that besides hallucinations is the black box component. So not knowing exactly how we arrived at a certain outcome. The Silicon Valley guidelines for arbitration suggest something they call explanative AI, where the AI should be able to explain to a certain point how it arrived at that decision. But it's able to explain that to a certain point. At there's a certain aspect of LLMs we cannot grasp. So how do you deal with that in a legal manner where everything has to be reasoned, every reason has to be, articulated? That's probably more so for judgments than for arbitration, perhaps. But just raising that as an issue.
I can just jump in
I'll
with a
just
final
add to that
point.
Oh, sorry, go ahead, Christian.
One that I think is important when using this on client matters is to make sure the client is taken along for the ride. And by that I mean the risk there is that the client has a mismatch of expectations about what you are doing with their information and the associated risks. So, I mean, my practice and my firm's practice is always certainly to make sure we've got a clear, informed consent from the client before using these tools. And they're usually very enthusiastic about it because they think it's the best way to minimise legal spend. But there are different clients that do have different internal policies and different risk tolerances. So I think it's just critical to make sure you're fully transparent with the client in bringing these tools in.
Right. Well, at the risk of prolonging this topic a little further, I just will make my own observation on it, which is that. Obviously, from the court's perspective, hallucinations and those sort of risks are of concern. But everyone who's not a self-represented litigant has an ethical responsibility not to mislead the court. And when they're signing off on pleadings or submissions, they're signing them to make sure they're accurate. So, provided that legal practitioners adhere to their ethical obligations, that risk should be appropriately mitigated, and if not, there'll be disciplinary consequences for it. And the other that surprises me sometimes in these cases is that the adversarial system breaks down, because typically if someone is selling you a pup, the other party will bring that to the court's attention as rapidly as possible. So there are already within the system checks and balances against this, and in many ways it's no different to relying on a junior lawyer preparing a document for you and you're just signing it. So I just allude to the risk that there is a framework already in existence that can cater for these kinds of problems. So that's really an observation, really, more than anything else. So if we could perhaps apropos what I've just said, which is obviously this court's in the process of developing its response to there's been other courts who have I suppose, been a little bit more rapid in in developing guidelines or practice notes in this area. But perhaps, Tom, if you could explain to us how Australian courts, at least, have approached the question of disclosure of generative AI in court proceedings.
Yes, thank you, Judge. So there's been different approaches in different jurisdictions, and as many of you would be aware, New South Wales at the moment appears to be the most developed in the sense of having issued quite a clear practice note in relation to the use of generative AI by both practitioners and judges in New South Wales. And the New South Wales example, the practice note, is probably a good extreme because it seems to be the most restrictive from what we've seen from not other courts but other bodies in different jurisdictions. So under the New South Wales practice note, disclosure must be given in respect of affidavits, witness statements and other character references to the effect that Gen AI has not been used in the preparation of those documents. So not only is it a requirement to disclose, the disclosure that is required is that you haven't, and if you propose to do so, leave must be sought in respect of the manner in which it's proposed that Gen AI will be used in the preparation of affidavits, witness statements or character references. And the reasons for that are fairly obvious. The deponent of an affidavit, witness statement needs to be giving their own evidence in their own words, and it shouldn't be embellished in any way. As Justice Fuchel has pointed out, this is all legal practitioners have an obligation to ensure that is happening when they're assisting in the preparation of those materials. But the New South Wales Supreme Court has taken this position in respect of those documents. In relation to written submissions, it's slightly different. When Gen AI has been used in written submissions in New South Wales, the position is that the author must verify in the body of the submissions that all citations and other authorities exist, are accurate and are relevant to the proceedings. And funnily, they do note that such verification must not be carried out by a Gen AI tool, but that verification should be carried out by a lawyer. So interestingly, in relation to written submissions, there doesn't appear to be the positive obligation to disclose that you've used it, but if you have, you must state that everything that is cited is relevant and accurate, and so that impliedly obviously means that you're required to disclose it. In relation to expert reports, it's a lot more restrictive, and leave must be required before it's used in any form in that respect. So that's the New South Wales position, which seems to be quite restrictive and firm in that respect in terms of disclosure. Interestingly, in comparison to that, the Law Society of Western Australia's submission argues that mandatory disclosure is problematic. It considers that disclosure, it uses the example of disclosure in large-scale and complex litigation in the pre-litigation phase or during case management or a trial may create significant administrative burdens and expense, which could offset the time and cost efficiency of using Gen AI in the first place. It notes the potential for AI-generated work to be perceived differently to other evidence which the disclosure does not apply, and that the use of AI should not inherently arouse suspicion regarding a witness's credibility or a practitioner's conduct. One of the reasons for that, as the judge has pointed out, is that the system has a number of checks and balances in place already to regulate those matters. And the Law Society also submits that it's a more appropriate matter for cross-examination of a witness, for example, than a mandatory disclosure in relation to the manner in which the witness has prepared their outline or given their evidence in chief, for example.
Can I just ask, you may not be able to answer this question, but In the New South Wales experience, when we're dealing with the use of generative AI in a forensic task, is the court inundated with applications for leave? Because I would expect that, given where we're at with generative AI, it must be almost impossible not to use it in some form in the preparation of evidence.
Quite, and I don't know the answer to the number of applications in New South Wales, but it is a point raised by the Law Society where they say you've got different levels of sophistication in terms of parties using the court, and some of those parties using the court are not actually aware that they're using AI at all, so they might not have the capacity to provide the disclosure because they're using it without knowingly understanding it. But I think that's a very good point, because it's very hard to avoid it in some degree, and it would be very hard to hand on heart make a disclosure without any caveat that there's been no intervention of AI in any way.
And as a case in point, the recent Murray decision that I mentioned, where the junior lawyer didn't realise that Google Scholar had generative AI built in these days.
Right, but the references still weren't checked.
That's correct. Yep. So it's no excuse.
All right. Well, I think I'm right in saying that there's a slightly different approach that's been taken in New Zealand as well, which is a bit more of a guideline approach and reminding parties of their ethical or admonishing them to adhere to their ethical obligations, as opposed to prescriptive rules. There are obviously different reasons for taking each approach. Perhaps Kristen could tell us how the Institute has approached this question in the protocol.
Yes, absolutely. In the Ciarb guideline takes a more kind of balanced, not a prescriptive approach to disclosure. The use of AI by parties, this is addressed in Part 3, Section 7 of the guideline. And basically, the rule is that you shouldn't have to disclose any use of AI, or emphasis on any, meaning, like, let's say for the non-contentious uses like spelling and grammar check and unofficial translation, transcription, areas where, as you guys have said, it has almost become ubiquitous in some parts of the practice and is therefore a little bit more low risk, but that parties may have to disclose the use of other types of more high-risk AI tools. So to help folks kind of navigate those issues, we came up with a test, which is that disclosure may be required if the use of AI has an impact on either the evidence, the outcome of the case, or otherwise involves some kind of delegation of power or decision-making by an expert or counsel. So the second thing I want to say here is that even though we're talking about, this section deals with the use of AI by parties, arbitrators will play a really important role, because they're the ones who are going to have to, for example, maybe require one party to make a disclosure. And so I think it's really important that these discussions about the use of AI happen at the outset of the case, because we have to recognize that in some cases there will be disagreement between parties about the use, and so arbitrators will need to make some sort of ruling about that. And again, this is an area where we may expect to see arbitrators and counsel perhaps actually need to engage some experts to help support that determination. So I'll leave that one basket there in terms of AI use by the parties, and I'll quickly touch on the use of AI by arbitrators, which in our guideline is in Part 4, Sections 8 and 9. And here the position is pretty simple, which is that arbitrators are effectively encouraged to consult with the parties on the use of an AI tool by themselves, and that they should provide parties an opportunity to comment on that potential use. If one party disagrees, then arbitrators should refrain from using the relevant tool. Where parties agree, the guideline still states that arbitrators should step back and review whether, in light of the circumstances of the case in front of them, they should still consider whether or not they should use that tool, even if parties agree that they can. So, for example, some of the relevant factors may be other mandatory rules or regulations, et cetera, and that then at that stage, arbitrators should make a determination on the use and disclosure. So that's kind of the general approach that the guideline sets out.
So it sounds as if the Institute has taken a sort of a halfway house to some extent. It's not as prescriptive, but it's also got some elements of prescription in it.
It does. This was a difficult area where there was, it was really highly discussed amongst the expert group and about how to kind of get that balance right. And I think that's where we landed on this sort of halfway house as you described it.
Well, I think, to be fair, there's always going to be a wide range of views about this, and so often you have to reach a compromise on the position on it. Transparency seems to be, however, at the very least, the order of the day, so that everyone knows the extent to which it is being used in some form, if it's not self-evident from practice. This really leads to the next, I guess, major topic, which I'll start, at least to begin with, to Tom, which is whether there should be any prohibition on the use of generative AI in legal proceedings, and if so, for what kinds of legal work product should the prohibition apply?
Thank you, Judge. So firstly, to start with the New South Wales position, that in New South Wales there is a general prohibition, but it's slightly different to using AI in the usual sense. The prohibition is in relation to information which might be subject to non-publication, suppression orders, or the implied harm and undertaking. Such information is prohibited from being used in or entered into a Gen AI program because of the risk that it can be used for another purpose, or that the confidentiality can be contravened. Now, I understand that in the context of public or open source, if that's the right phrase, Gen AI platforms, but obviously firms now have got very sophisticated internal systems with high levels of security. So I think that risk of breaching any implied undertaking or any confidentiality issue will soon dissipate as the technology increases or improves in that respect. And it may be that the prohibition is changed to just relate to open source or any sort of public software where there is that risk.
So you're referring here to training a model on in a closed system as opposed to an open system.
That's right.
So just pausing there though, within, do you think, obviously bringing you on the spot here, is it your view that training on an open source model it would stand to reason that there would be the risk of confidential information entering the wild if you use open source model to do any activity on documents, say for example provided in discovery?
Yes, if documents are being entered into that open source software, and I don't understand the technical side of it so much, but I understand that there is certainly a risk that is perceived and understood of confidentiality being affected.
So does that equate to a prohibition on the use of open source generative AI where the training data includes confidential information?
I would say so, yes, because it would have to involve the input of it into the open sphere in some way or form. As I've mentioned before, in New South Wales as well, there's also the prohibition against using it to generate the content of affidavits and witness statements, etc. and there is quite a strong prohibition in terms of using it in the context of expert evidence. And interestingly, in the New South Wales practice note, the restrictions on using it with expert evidence is far more comprehensive than affidavits and lay evidence, and perhaps for obvious reasons. Again, the WA Law Society has taken a fairly different approach and does not support any kind of formal restriction or prohibition, as it considers that has the potential to stifle innovation and delay improvement to access to justice, etc. The Law Society WA instead advocates increased education of practitioners of the risks and benefits of AI as opposed to any kind of blanket prohibition.
Right. Well, again, I
If
think...
I can just jump in, sorry.
No, you go for it. You're probably going to say something much more erudite than me.
No, I bet. Just on the question of the confidentiality, so it depends typically whether you're using a free tier or paid tier. So most paid tier, not most providers of GPT services, say ChatGPT or Claude, if you're paying, they will not use your data to train their models, and thereby your data is more secure. But if you're using, say, OpenAI ChatGPT free, by default, your data that you're inputting is being used to train, unless you go through settings and there's a way to actually opt out. But by default, you would be using. So that is technically the difference.
Right.
It's that old saying, if you're not paying anything, then you are the product.
Correct.
Yes, I think it's probably worth just dwelling on this for a little bit, because I mean, this is where the rubber hits the road to some extent, I think, in this area. And it is, I mean, there's a tension between cost and usage here, because I can see that when a lot of expert reports involve the analysis of large amounts of data, and if there's one thing I expect generative AI to be quite good at, it would be analysing large amounts of data and providing some summaries of it in a useful form. Obviously, this has all taken place since I've left the profession, but at the time I was in it, you get typically an expert report that was written by someone highly paid who had thousands of underlings who did all the data analysis, and they would say, I prepared this report on the basis of all this information that's been essentially assembled for me by my minions, and I've checked it and it's all good. That, I imagine, would now take place largely by generative AI. So I'm not sure I see the huge difference between those two processes, as long as the author has in fact verified that the information is accurate. Any thoughts from the panel on that one?
Interestingly, we don't have the same level of control, obviously, over what the expert's doing, save for ensuring that they've read and understood the code of conduct. So it's harder for us to regulate what they do, and they're not subject to the same professional obligations, even though that comes through the code of conduct. But obviously, and many of our members here today and on the panel are practicing in construction dispute resolution, including arbitration litigation. And as you know, the volume of data that the experts have to analyse in those cases is just phenomenal. And it's, in my mind, it's inevitable that AI will need to be used to make that process more efficient and more cost efficient and time efficient.
So as a decision maker, whether you're an arbitrator or a judge, whichever way expert evidence is approached, it still has to reveal the chain of reasoning in a way that exposes how the experts got from A to B. And if it's a black box idea, where they've just chucked it all into a generative AI tool and it's come up with an answer, that's not going to assist, because unless the judge or the arbitrator knows how the information's been analysed. So it seems to me that whichever way it's analysed, the information has to be the chain of reasoning has to be exposed and explained in the Makita sense appropriately. So I don't know that prohibition is necessarily going to carry the day on this, because it seems it's just an inevitability about it being used by clients, by experts, and ultimately by law firms, because I suspect pressures of cost effectiveness is going to drive the clients are going to drive what the law firms do.
I think in both arbitration and the courts, I mean, the justice system depends on professionals taking responsibility and being accountable for the work within their remit. And much as the court would, I would suspect, rarely inquire too far into the council's process that has been undertaken in preparing submissions down to the level of preparing notes and working up a draft, I think the end game from my perspective is a similar thing. The professional, the expert who's running the process has to explain how they've done it, but ultimately they're accountable for having followed a proper process and having a robust product.
All right. Well, I think we've been making relatively slow progress, but quite interesting progress for those who are listening and observing. I think it means we're going to probably run out of time to deal with some of the topics, but I think at this point it would be useful to throw over to Kristen again to put the arbitral perspective and perspective of the Institute and how it's approached this question in the protocol. Obviously there are a range of views and approaches, certainly in the court system, to this question. What's the practice of what's a recommended practice of the Institute in this regard?
So I'll be brief here because I know we want to squeeze in another set of topics, but the guideline does not endorse or prescribe any kind of blanket prohibition on AI use or admissibility of AI generated evidence or material in the record. Instead, it sort of reaffirms two ideas. One is party autonomy. So parties can agree how AI will or will not be used in proceedings, including by incorporating some language from the appendix that I referenced, that kind of template agreement and procedural order. So there's some examples of how parties can agree that. And the second idea here is tribunal discretion. That sort of runs throughout the guideline, which is that where parties have not agreed, that the tribunal may restrict or prohibit AI use in certain contexts, particularly where there's a risk of unfairness or prejudice, where the AI output is unverifiable or unreliable. This touches on this idea that we've been talking about and that Eli raised earlier about explainability and being able to verify the AI outputs. Tribunals can also restrict or prohibit AI use if the parties lack kind of equal access to similar tools. We talked, some folks have touched on, the idea that big law firms now have enormous resources and proprietary tools out there. And so sometimes there's a sort of inequality of arms there. And the other area where tribunals can restrict AI use and access, an AI generated material or supportive material, is if it affects the integrity of the record or the enforceability of the award. And so again, if I can sort of draw a through line, it's not to ban, but just try to equip tribunals and parties with the tools to use their discretion to manage the use of AI in a way that still preserves that fairness and respects autonomy. And I can sort of touch on a few of the factors that the tribunal may consider when it's looking at AI generated material, but maybe I'll just pause there in the interest of time.
Thank you. Now, I'm reliably informed we started slightly late, so we can run a little over time, because I know everyone's very keen to ensure that they get their full one CPD point, not 0.95 of a CPD point. So we will, this is quite a bit in this topic, but I think what I might do is introduce the topic and then sort of throw it open to the panellists to fight out over who wants to talk about it, because it's quite a big topic. But at this point, up to this point, we've really been focusing on how generative AI is used by parties and their counsel largely in arbitration, but also in court litigation. We've touched at times upon how it might be used by arbitrators, not so much by the court. So really, I am in a position to explain to the extent to which it's being used by the court, this court at least, but perhaps it's better for me not to go into that and have Tom tell us about what his understanding is of how it's being used by courts, plural, at present. And then perhaps I could chime in and explain where he thinks it might be going in the future, and Christian can tell us how it's been used by arbitrators, and I think that'll all have time for.
Thank you, Judge. And I've got limited insight into how judges or arbitrators are actually using it. Christian may have some examples of where they've been caught out, because I know that arbitrators have been caught out in other jurisdictions where they, for example, copy and pasted awards. I think that happened in arbitration in India recently in a related dispute, and it was successfully challenged on that basis. Again, just referring to the New South Wales guidelines, interestingly, in the context of judges, it stated that judges should not use Gen AI in formulating reasons for judgments or assessment or analysis of evidence, etc. Interestingly, the word used there is should, as opposed to should not use it, as opposed to must not in the context of practitioners where there's a prohibition. And there's the Administrative Review Tribunal has a code of conduct as well, which is a bit stronger than that says that their members must not use JI for preparing in a substantive way the decisions. And obviously there's a concern that AI may intrude in some respect on judicial autonomy and independent decision making. What I'm quite interested in is the cases that will no doubt flow out of the arbitration scene, where there are judicial review applications for a failure to afford procedural fairness as a result of an arbitrator using artificial intelligence. There's been quite a comprehensive report prepared by the Australian Institute of Judicial Administration, which focuses on quite comprehensively, as I said, on the use of AI by judges. And it does have a particular section on the risk of compromises to procedural fairness if parties feel like they haven't been heard because of the role that AI has played in either analysing evidence or preparing reasoning for in relation to the preparation of a decision. And I think that we will certainly see some insightful and enlightening decisions that come out of the arbitration world when awards that have used AI are challenged under, on the basis of judicial review in a domestic court in Australia, for example.
Well, I actually can see application for it in more an administrative function in the court, actually, more so than more so than the actual writing of judgments. And indeed, if it becomes a tool that's actually useful for legal research or for proofreading or those sorts of things, I can see how it can have some utility that doesn't involve reasoning in the future, if it's any good at it.
And I should note, Judge, on that the New South Wales direction does not so much encourage it, but say it's fine for what are described as secondary legal research by judges, so long as they familiarise themselves with the risks, etc.
And Eli, what's the future hold? Oh, we're losing people one by one. You're back.
Yeah, I am. Sorry about that. One area, can you hear me now, by the way, or is it bad?
Oh, we can hear
you. One area that we touched on briefly is agentic AI, and that's just to explain. Agentic AI is when AI acts as a agent with its own cognition, not quite, but decision-making capacity based on a certain set of rules. And they normally specialize in a particular function. So, for example, you could have one AI agent that's, all about procedural fairness and whether certain documents are admissible or not admissible. Another AI agent would check for timeliness and so on and so forth. And what I think we'll see over time is more reliance on AI agents, potentially either to assist the arbitrators along the way, so by basically acting as a secretariat or support staff to the arbitrators, or with time you could see actually AI agents replacing the arbitrator for small claims where it actually makes more sense to have a AI decision maker and to have an in-person decision maker for that. I believe that would be just very small minor claims. That's one element of change we might see. Another one we might see is where some of the parties coming could be AI-related parties. And I know it sounds a bit far-fetched, but already now we have decentralized autonomous organizations called DAOs. Certain jurisdictions recognize them. These are organizations that run without a board, without the shareholders, but run based on a preset of rules that are hardwired in codes, be it smart contracts, and likewise AI agents could actually be the ones entering into an agreement, having a dispute about the agreement, and effectively being the parties before the court as well. So just a bit out there, but potentially where we might see things heading in the future.
Right. And Christian, how are arbitrators using it, to your knowledge now?
Well, in the lead up to this, I did have some discussions with colleagues to get views on this. The two interesting examples I have heard of were one arbitrator is using AI tools to essentially do a proof check that they have addressed all of the issues raised by the parties, so feeding in the parties' submissions and pleadings, and then using it to do that check on the draft award. And the second one that I have heard of is really a similar way to what I mentioned before with counsel using these tools in terms of sifting through, summarising, and distilling information. I think just on that one, it's important to be mindful of the risks there, particularly with decision makers using tools for summarising, in that there is a risk there that the AI tool doesn't pick out the document for summation or the point for summation that the party considers critical to their case. So I guess just reinforces the need, at least at this point, for having human minds directed to arbitral awards. There's just no way about it.
All right. Well, I think that brings us to the conclusion of the substantive topics that certainly I wanted to ask you, the panellists, about. Unfortunately, we, through technical difficulty, which is somewhat ironic, given the topic of today's seminar, we've lost Jeff. He hasn't returned to the seminar. So the task of thanking the four panellists for their insights and time falls to me. So thank you to each of you for making your time available, presenting your views and preparing for today's seminar.
Judge, may I be so rude as to interrupt to also, on behalf of Jeff and the Institute in his absence, thank yourself and to the court for enabling this session. This is what we hope will be the relaunch of our federal court series, and we hope this will become or resume being a regular schedule of such seminars, including those in person in future.
Thank you, Christian. I was just about to make that plug myself, actually.
Stolen your thunder, I'm sorry.
Which is to say that before my time in the court, there's been a long association between the Institute and the court in running these seminars, which I think may have had a hiatus as a consequence of the COVID-19 pandemic. But we're getting it back on track, and certainly from the court's perspective, more than happy to participate and to facilitate any form of continuing legal education. And in the arbitral space, of course, the court has a role and a function to play in international arbitration. And we'd like to see the relationship continue with the institution, inside the institute. So thank you once again, all of you, for your time, and those who are participating. I can't see you, but thank you for making for attending, and we hope again this will be the first of another series of seminars of interest to participants and the members of the institute. Thank you.
Thank you.